Maybe we can start. Good afternoon to everyone. My name is Carlos Bernal, and I am professor at the University of Dayton School of Law. And for me, it's a real privilege and a pleasure to be here today and share this event, which belongs to the series of the University of Dayton School of Law Latin American Engagement Seminars. We have two presenters of first class tonight, and they are going to talk about one topic that is, I think, key for every lawyer, is writing skills. And before I give the floor to Dean Strauss, I just wanted to mention something that is of interest of everyone and is related to the topic, is that I work as a justice of the Constitutional Court before joining the University of Dayton School of Law. And one of the skills that I requested for the people who work for me in my chambers was to be able to write. But that was very difficult to find. So this is a skill that we need to train better in all the schools. And for this reason, I think all the attendees, they would appreciate the reflections that Professor Erica Coran and Professor Denise Abade will make today in this series. But before we begin, I just wanted to give the floor to Professor Andrew Strauss, who is the Dean of the University School of Law. And I just wanted to mention that in the bottom part of the Zoom, there is a sign that it looks like word is like a circumference, and it says interpretation. If you would like to listen to this event in Portuguese, you can connect there and you will hear the interpretation to Portuguese. Thank you so much. Dean Strauss, the floor is yours. Thank you so much.
Thank you very much, Professor Bernal. And it's truly my pleasure to introduce the seminar this evening. Our new partnership with McKinsey is incredibly exciting to us at the University of Dayton School of Law. It started out in a really big way. I think we have in our LLM program, I think we have 11 students from McKinsey, and we're looking to grow that and to really develop all sorts of connections at the faculty level, to begin to work together more, have exchanges and do all sorts of things together. So I think this is a really exciting beginning, really, compared to where we have to go. And I think, as Professor Bernal said, I think the topic tonight is one of great importance. Professor Curran, Professor Bernal, and I were all in a faculty meeting earlier today where we discussed our own writing program and the need for students to be able to write. I couldn't agree more with Professor Bernal about the importance of writing, and it's a difficult thing for lawyers to learn to do well. And so I think there's challenges around the world in that, and I'm really interested to hear, sort of from a Brazilian perspective tonight, what the challenges around learning to write well are. I often, when I think about this topic, I'm reminded in my early days of teaching, in some conversations with students who told me, well, Professor, I really do understand it. It may not look like I understand it by reading what I've written, but I really do. And that's always confounded me over the years when I've heard that over the years more, in that I'm not sure with legal thinking, since it's analytical, if you really understand it in your unconscious, it's a little bit like the tree falling in the forest, and if there's nobody there, does anybody hear it? I'm not sure what that means to understand it in a way that is not articulable. So I think it is incredibly important as a topic. And I also feel like, I do a lot of things day to day. I work on budgets and all sorts of things. But this sort of interchange of ideas and finding out how people from different places think about things, I think this is really one of the great things that we do around the world as legal academics. We generate ideas, we teach students, and this brings together both the idea generating part of what we do and the teaching part of what we do. So I'm really excited to hear tonight's discussion. and wish to welcome everyone. Thank you.
Thank you so much, Dean Strauss. And I would like now to give the floor to Professor Erica Coherence, who is my colleague here at the University of Dayton School of Law. And just want to remember everyone that we have a Q&A sign also in the bottom of the Zoom. If you have questions, please write the questions there, and then we will take those questions at the end of both presentations. Thank you so much, Professor Coherence. The floor is yours.
Thank you so much, Dean Strauss and Professor Bernal. And I'm excited to be with you all this evening. And I just want to say I did my study abroad in law school in Brazil, and it was just a tremendous learning experience for me. And so I just have such great admiration for all of you, and the legal system in Brazil was foundational to my thinking about law. So, share my screen. Here we go. So I will begin by talking a little bit about where in U.S. law schools we place legal writing and the sort of transformation of a law school experience in legal writing. I myself am an immigration attorney, so I bring a lot of my practical experience to my teaching as a lawyer. I think a lot about how to keep legal writing education relevant, because I still engage in practice in my field in immigration law and also family law. So in the United States in law schools, we have mandatory requirements. Students have to learn legal writing. This is not anything new, but I'm sorry, I just wanted, I'm having some feedback. I'm not sure if anyone else is. My apologies. Okay, so I'll just continue. So we have legal writing courses as a requirement, and law schools are governed by the American Bar Association. And so how many courses we must have are dictated to us in some instruction, but we really, each program develops a unique approach. However, there are two main sort of foundational sets of writing skills. We focus on predictive analysis, so outcome predicting memorandum, positive and negative writing to start out for students of a given action for an attorney client. I'm teaching right now first-year law students, and we are just working on our first memo, and it's a memo for a partner. And so it's a simulated problem where the students are preparing a memo for the partner on a landlord-tenant issue. So they are working on predictive writing at this time, writing for the partner to see what the legal options are. And then we cover also persuasive analysis, motions, and briefs. So not as widely taught in law schools. Many law schools, and we do here at the University of Dayton, also include other types of writing courses, transactional legal drafting courses. We know many of our students are not going to litigate. We know they're going to be doing transactional work, so we offer those courses, and other courses that focus on appellate advocacy and interdisciplinary writing. We were just, as Dean Strauss mentioned, today in a faculty meeting talking about some more specialized writing courses, adding those to the curriculum to increase writing experiences for students that they will use in practice. So the American Bar Association, which governs American law schools, requires that we teach legal writing courses, and they have recently just increased the skills component of legal education in the United States. So we're doing more and more with legal writing and some of the other foundational professional skills that students will use, where they are synthesizing that doctrinal law that they're learning and putting it into action so that when they leave law school, they're prepared to practice. And I think it's helpful to talk about the differences in our legal system in the United States, our legal education system in the United States. Our students are coming out of 4-year bachelor degree programs typically, and then attending law school. So they've already had 4 years of education. It's a graduate program. So they've had some writing. It's different writing. I've been hearing that this semester from my students, how different what they're doing in class and law school is from the types of writing they did. There's also no set prerequisite for what type of undergraduate degree you have to attend a U.S. law school. So our students are coming from a variety of different backgrounds. I have engineers, I have English majors, I have social workers, I have all sorts of different backgrounds in my course, and they all did different writing in their undergraduate experience. So they're bringing a lot with them, but it's varied. And so we take the approach of starting with those foundations. So the American Bar Association standards tells law schools what the minimum writing courses and other courses that we have to include. And one writing experience must be offered in the first year, and at least one additional writing course must be added after the first year. And all of those have to be faculty supervised. We also incorporate writing into many of our other doctrinal courses. Many professors are now infusing writing assignments into their courses as part of their assessments beyond the writing that one does for an exam. And law schools are now, and this is fairly recent, required to offer experiential courses such as law clinics or field placement internships. This is particularly important for us in the United States because we don't have any mandatory supervised practice period. After a student graduates from a U.S. law school, if they pass the bar exam, they can go out and practice law. They could hang a shingle, start their own business. They be working for someone else. They don't have any type of practical period, so we need to incorporate that in our Juris Doctorate programming. And so law schools are now required to offer experiential courses where students get to practice those skills, and often that does include drafting, whether it be transactional work or litigation-related drafting. Students must do that. And we also sometimes incorporate that in student participation in pro bono legal services. Another foundational difference for us in the United States is we do not have free government provided attorneys for civil matters. If we have legal aid organizations providing services, but no one has necessarily the right to free counsel outside of criminal proceedings. And so we also teach our students about volunteering and pro bono services and get them some writing experience through that. So the ABA also provides interpretations for law schools. The American Bar Association, they direct us to consider certain things in evaluating our writing experiences and writing projects that we assign to students, and assessment of those written products. So I can tell you that for us here at the University of Dayton, in our first year curriculum, students will do 4 significant legal writing pieces, 2 in their first semester and 2 in their second semester. And in the first semester, we focus on predictive writing. In the second semester, we focus on persuasive writing. And we hope that the students will, after the course, then polish that writing product, take the feedback from their assessment grades and improve that writing product and use it as a writing sample when they're looking looking for employment placement or internship opportunities. So we have two courses in our first year, and we call them lawyering process because we incorporate other lawyering skills in those writing courses beyond simply writing. We're working with students on research skills, organizational skills. We introduce them to the legal system. We introduce them to aspects of access to justice issues we have in the United States. This particular semester, all of our legal writing professors are incorporating a book on housing and eviction, which is obviously coming up as a big issue post-COVID, or maybe currently in COVID, where mass amounts of Americans are facing potential homelessness. So we have a book that the students read. We've shaped our legal writing problems to incorporate some of the social justice issues that are current. And so they're writing about issues of individuals facing eviction, facing poverty, and also learning about those aspects of how the legal system works and also doesn't work well. And in our second semester, in our first year, we also include oral argument. The students have to do an oral argument before their professors and practice those skills as well. And students also, so we typically offer these courses in fairly small classes. They're capped at 25 students, and that's so that the professors can provide more detailed, individualized feedback. So we meet with the students individually as well as teaching the classroom component. They all have individual conferences with us where we provide individualized attention on their writing and their skills. So this is the basic course description for our first course, which is a 3-credit course, which means that the students spend 3 hours a week with us in class on that particular topic. And then that second semester course, as I said, we work with them on oral advocacy as well as the writing, and we focus on more in-depth research skills and persuasive writing. This is also where we tend to transition to federal legal issues. In the first semester, we focus on state law, and then the second semester, we focus on federal law for us, which is very significant. And students at the University of Dayton also have a mandatory upper level requirement, and I think we just added another course today, but we have appellate practice and procedure and transactional drafting as options, as well as I believe we're also offering something in IP, intellectual property, coming forth. So the transactional drafting course, this is a wonderful option for students who know they're not going to litigate, and you don't have to choose any kind of track when you're in a U.S. law school, but it's really helpful if students have an idea of where they'll be working, if they're going to be doing a lot of contract drafting, if they're going to be in a business field. It can be helpful for them to take a course that supports their ultimate goal. And then also the other option of appellate practice, and the focus on the role and function of appellate courts and drafting appellate briefs and focusing on the construction of legal arguments at that stage. And all of our students who take this course are not going to necessarily go on into appellate advocacy, but the in-depth writing really supports the expanded skill set that they'll have. In addition, as I mentioned, we also do require these experiential opportunities because we don't have that post-graduation. So we have a requirement that students do an externship or an internship. So they go work in a law office under the supervision of an attorney, and they typically do incorporate some writing in that experience. And we want them to go to that experience with some skills so that we get we get them good placements. And then we also have an in-house clinical program where students can work on real legal cases under the supervision of a professor. And often those courses are really writing heavy as well. Different types of writing, because it's not a closed universe. It's not something that the professor controls. I taught in a clinic for many years, and one of the things about the writing in the clinic is we would have one plan, and then actual case settles, or we're going a different direction than we thought we were. And so it's really good for the students to have those real life experiences of how a case may play out. So we offer those courses as well, which again, really important for U.S. law students who, after the bar, can just start practicing law. And we want them to have as much experience as possible before they do that. So we also try, as I mentioned, to incorporate various writing assignments within other courses. We also have capstone courses that incorporate some additional skills at the end of their time. And we really are, I think, in legal education in the United States, moving continually towards more additional skills within courses, recognizing the vocation and the practical aspects of lawyering. 50% of what lawyers do involves those skills and analytical skills and writing and client interviewing, taking depositions, preparing for trial. So it's really very important component of legal education. Some of the challenges, I will just say that we face, and I'm going to guess that our counterparts in Brazil also face, are, students' communication and writing skills being so connected with social media and communications on text, and this generation having grown up online with access to all these different forms of communication has changed the way that they write. Undergraduate programs are doing different things with writing, so students aren't coming in necessarily with the same skills that they may have 20, 25 years ago. And also students are also able to access a lot of assistive technology. When I was a law student, we were transitioning to online legal research, and I remember our professors were very concerned that we wouldn't know how to do legal research with books because everything was transitioning online. Of course, now much legal research is online, and now there's a greater use within practice of assistive artificial technology and legal writing, and students can access some of these tools. I know, at least for me in my course, we talk about the tools that are available, talk about how to use them, talk about the limitations, because I know students are going to be encountering things. Some of them are just focused on grammar. Some of them, such as Brief Catch, is one that I know some of my students are looking at. Actually tries to capture more of the legal reasoning and the format of the writing. So these are some of the challenges. We want the students to know how to do these things on their own and not rely on technology that may not be all that consistent, but also know that these things exist and make sure that they're prepared for a work environment where they may use them. So those are some of the challenges that we face. As Dean Strauss mentioned, we hear from judges, from other lawyers, that they want our students to come out prepared and ready to work and to write well, because it is so important to the work that we do. So we're trying to make sure that we're catching them in writing experiences throughout their legal education experience. I myself really enjoy this work. I enjoy seeing students take the law that they're learning in the classes of my colleagues and synthesize it and try to utilize it in a simulated practice environment. It's very exciting. So thank you all. very much, and I look forward to questions and hearing my colleague's presentation.
Thank you so much, Professor Curran. That was a wonderful presentation. We are receiving some questions, but we will hold a little bit the questions until the end of this webinar. Now, I would like to give the floor to Professor Denise Neves Abade, and after that, we will have the Q&A. Thank you so much, Professor Abade. The floor is yours.
Good. Okay, so good evening to all. I'd like to thank the University of Dayton for the invitation and greet the organizers for this webinar series through Dean Strauss, Professor Bernal, and our staff. I wish to congratulate Professor Curran for her lecture. It was a very insightful presentation about the legal writing skills teaching in US. I will talk about legal writing skills, considering my experience as a professor in Mackenzie Law School in Brazil and as a federal prosecutor, because in the federal prosecutor's office, in addition to my regular duties, I am one of the examiners for the entrance exam. In Brazil, prosecutors are considered magistrates, and the admission to public careers, such as judges and prosecutors, is by public examination. And one of the phases of the exams requires elaborate essays and answers to legal questions. So I have to evaluate also as a prosecutor, people's legal writing skills. And it's important to note that the American legal education system and Brazilian legal education system have some difference, especially because Brazil is a civil law country. Generally speaking, a civil law legal education begins earlier for most students, usually age 18 or 19, and runs longer. In Brazil, 5 years. But despite this difference, both countries share the same basic pedagogical goal, which is to train skilled lawyers and legal professionals. As a consequence, the teaching of skills such as legal writing is a high priority in both educational systems. And at Mackenzie, legal writing is taught as early as the first semester of law school when students have just entered the university. So writing skill training is deeply ingrained in Brazil legal culture as well in the US. So simply put, great lawyers are great writers. That's why legal writing is so important for law practitioners. The reason is that legal writing is the central medium with which a lawyer communicates her or his work. The most brilliant legal mind will have a difficult time in the legal profession if their writing skills are not on par with their ability to effectively read, research, analyze, and reason about the law and the facts of the case. So legal writing is a vital skill for any practicing lawyer. Students must learn to perform legal analysis and to write clearly. But there is one detail. The written word is everlasting. This can be a good thing if you are Shakespeare, or if you intend for your words to live on for generations. But when you are writing documents that provide legal advice, or that assert your opinion on a matter, everlasting documents mean long-term potential liability. These are technical opinions that will be associated with you, if not forever, at least for a long time. So a lawyer's reputation stands and falls to quite an extent with what they produce in writing, wherever the area he or she has chosen to work in, being a lawyer, judge, prosecutor, or professor. So legal practicing cannot be separated in any way from writing. The most important maxim for legal writing is this: begin with your main point. Legal writing is not about building suspense. If you are a student, the professor wants to know if you have enough knowledge. And if you are a lawyer, usually someone comes to a lawyer for an answer and they would like it straight away. They do not care to puzzle out the answer from the organized pile of information. Be clear, comprehensive, and concise in offering complete and correct information. Leave out irrelevant remarks that merely divert the focus on what is important. Keep your audience in mind when determining how much detail is required to make yourself understood. It can be helpful to remind yourself that you are tempted to advise or persuade and not to write a work of literature or poetry. Secondly, take the time to edit what you have written, ideally more than once. Every mistake in spelling or grammar will make your reader stumble for a moment, pause, and perhaps reread the sentence. Such an interruption takes away the focus from the argument you were trying to make, and it will inevitably leave the impression of a lack of care, and if you repeat it too often, of competence as well. Of course, polished legal writing skills do not come overnight. So seize every opportunity to practice. If you get the opportunity to work under supervision of an experienced lawyer and draft legal documents for her or him, make sure to read the final edit product so you can see what changes were necessary and what you can improve. In law school, do take courses in legal writing. It will, without a doubt, have a notable effect on your performance in every other class and on your proficiency as a legal practitioner. So the point of saying all of this is that your words matter. As a law student, as a legal professional, your words are often interpreted and misinterpreted to suit the needs of the reader. Accordingly, it is essential that your words be carefully crafted, concisely written, and fully reviewed before they are released from your control. So, both in the admission exams for the career of federal prosecutor and with my students at university, I see many common mistakes. The most common mistakes are they do not answer the said question. Instead, they answer the question they said themselves. They do not plan their answer and do not think about what they are going to say next. They do not structure their answer and fail to deal with their issues logically and in order. They write in an inappropriate and casual style, not suitable for the submission of law answers. They do not check the work thoroughly for spelling mistakes and for poor grammar before submission. Some sentences do not make sense and need rephrasing before submission. But other mistakes my students at law school make too are the students do not reference their work properly and are often guilty of plagiarism, whether they intended to cheat or not. And a student cannot construct their biography in an appropriate manner. So, having presented here the main mistakes, let us list what would be the basic principles of a good text, either for academic purpose or for the legal practice, which I believe are present in many legal cultures. The first of all, truth. Good writing must necessarily respect truth. Speak the truth, and even more so, recording it in writing is an ethical duty, an act of citizenship and respect for human rights, indispensable in social coexistence. Therefore, the written text must express concepts that we believe to be true. Lies and deceit cannot be part of our code of conduct. Please, no fake news here. Whoever writes must stick to facts and realities and cannot get lost in personal opinions or digressions. A text that is not truthful and that contains generic statements lacks credibility. So instead of guessing an unfounded opinion, it is good technique to write a more contained text based on concrete and proven data. When it comes to legal text, according to most legislation, neither unfounded claims nor alleged defense may be formulated. The law punishes the frivolous litigation, the abuse of process. For law students, I must say that honesty and truth are integral components of any scientific process. Therefore, the first duty of a good legal writer is to seek to achieve the truth in what she or he writes, avoiding any deviation in argumentation or imprecision. The second principle is clarity. Expressing one's thoughts without obscurity is an art which requires a lot of exercise until the writer gets used to write simply with short objective sentences that are easy for the reader to understand. Then we have another principle, coherence. A good essay must be coherent. The word coherence comes from the Latin coherentia, connection, harmony, and indicates the connection or nexus between facts or ideas, logic. In other words, it is necessary to have a logical discourse, if possible, based on the syllogism model, by which two premises are set, a conclusion follows. The important thing is not to contradict yourself. Once you have adopted a thesis or a chosen point of view, you must develop the relevant reasoning to the end, using well-chained arguments. Then we have another principle, concision. And the word concision also comes from the Latin concisione, indicates the act of cutting, of breaking into pieces. Concise means cut short, limited. To write concisely or to write with concision means to be objective, directed, not repeating ideas or words, not stretching the text unnecessarily. Then, of course, correctness. It is necessary to write in correct language that observes basic grammatical rules. Otherwise, the reader, she or he, has reasonable knowledge of the language, will soon realize the writer's insecurity and will not trust the text she or he is reading. If the reader does not trust the writer, the communication between sender and receiver is incomplete and both lose time. Then comes the second step. Read what's written and start correcting it. The correction almost always includes a series of cuts. Usually words are crossed out or deleted. The text is cleaned up, removing everything that is unnecessary. Then precision. First of all, it is necessary to plan the text to be written. A brief summary, an outline, notes, draft, anything should precede the writing, which should follow a script that will define the dimensions of the paper. If it is an academic exam, the student must calculate the time available for writing, the possibility of consulting legal text or the prohibition of such consultation, how many words it should have, and all the other factors that involve this moment. When the work requires a large scope, like more complex papers, theses, planning is indispensable so that the result is a precise text, well developed, but lean, in which all the principles of good writing are linked. Then simplicity. One of the secrets of good writing is summed up in the wise lesson of Paul Valéry, French poet and philosopher. Between two words, always choose the simplest. Between two simple words, choose the shortest. A great Brazilian poet, Carlos Drummond de Andrade, said, writing is cutting words. And in the same way, Hemingway gave the advice, cut out everything else and stick to the essential. So people, follow the great writers. And do not fool yourself. Simplicity is only achieved through hard work. And another principle is knowledge. In writing, it is indispensable to know the subject on which we are going to write. If you now give me a blank page and ask me to write the history of Dayton, Ohio, for instance, I can do that. I can do that, unfortunately. I don't know the city nor its history. I can only write about this and other topics if I have time to think, gather material, consult books and the internet. It is not honest from an intellectual point of view to write at random or with disregard for facts and realities, as if the reader did not deserve any respect. In fact, to write well, it is necessary to know the subject, research it, elaborate a scheme to be developed, and only then write the text. Many students, when faced questions they don't know, they start guessing the answers, or they ramble on, and please don't do that. Dignity. In legal writing, whether academic or not, one should not use slang, jokes, commonplace. In such case, the text must obey the rigors of the polite language without exaggerating, without abuse of vulgarity. A poorly placed joke, sometimes a simple vulgarity, lowers the level of the text and makes the reader lose concentration. From then on, it is difficult to resume the discourse and maintain attention and interest in the text. But that's not all. Elegant writing does not offend or insult. It deals with issues in an elevated manner, and it avoids the obvious. And then creativity. Okay, technical writing, though restrained, can perfectly well be creative. Indeed, it must be creative. It is important to know the difference between creative writing and literature review. And the way you presented an idea, the format, is as important as the idea, the substance. The secret of good legal writing, it has been said, is to know precisely what one wants to say, but not only that, it's also to know how to say it. So, of course, based on these principles, there are peculiarities in the legal writing of each legal culture, because law is language, since language that constitutes legal rules, and language vary according to the culture of each country. And it is always good to remember that the legal requires the construction of a discourse that can convince the other of the veracity of what is intended to prove. For this reason, legal language relies on the principles of classical logical to organize thought. Because of this, the legal word values specialized vocabularies so that an excess of words with diverse meanings does not hinder the symbolic representation of language. This is why legal writing reflects its own language, which is a scientific language, the language of the science of law. Most of us go to law school not to become students, not to become scholars, but to learn to practice law. And you put your legal education into practice by researching, analyzing, and writing about cases and answering questions. And you will refine these skills throughout law school and your career. There is no magic to it, just an interwoven process of research, analysis, and writing that enables you to be called a lawyer. Thank you very much for your attention.
Thank you so much, Professor Abadi, for that wonderful presentation that illuminated many things that are, I think, very important for all us as legal professors, law professors. I have 3 questions here in the Q&A section. I'm going to read the questions. The first one is for Professor Curran, which is the following. Whether your presentation address the point of the classes that are offered in Dayton, but whether in addition to that, you would like to say something about the substantive legal analysis of the legal writing pedagogy that lies in those courses or in those classes.
I might need some clarification on the question. I'm not.
I think the question is about the legal writing pedagogy that is behind the whole program of building the legal writing here in Dayton.
Well, I think foundationally we look at building blocks, right? So all of the things that Professor Neves Abade spoke about are pieces that one builds with. First, we start with teaching the students how to read cases, right? And how to analyze and synthesize the law. Look for an understanding that goes beyond the explicit rules. Look for those deeper analysis. And then we also really work on teaching them the structure. We also incorporate grammatical refreshers and ensure that they're coming into this with their skills polished, right? They have to not make those kinds of mistakes, because in practice, if a judge or another practitioner sees a piece of legal writing that's full of grammatical or spelling errors or some type of error, they will stop reading. And that impacts their impression of the case, their impression of the lawyer, and you're not an effective communicator. And so it really comes down to effective communicating. I know in my courses, I really focus on plain language for lawyers, moving away from the tendency students have to think that if they use complicated sentence structure, passive, convoluted sentence structures and voice, that they're sounding more like a lawyer because it sounds fancy. But we need crisp, clean, clear writing because we don't have a lot of time, right? You have a very short window to present your case. You have to do it succinctly to get the attention of whoever the deciding body is or the person you're trying to influence. So I would say foundationally, that's where we start.
Thank you so much for that answer. Now we have an answer for a question by Professor Mark Wojcik from the University of Illinois Chicago School of Law to Professor Abade. And is the following: what books or materials are used, if any, for teaching legal writing to law students in Brazil?
Well, we have a lot of books about legal writing themselves, and we have then some that are specialized in legal writing for criminal cases, legal writing for civil cases, legal writing for judges, because we have to, as I was saying, when we have public careers and you have to apply for you want to be a judge or a prosecutor, we have these exams, and the examination have to write an essay. So you have a lot of books about how to write as a judge, and you have to train that, and we have these specialized books as well. And in all the disciplines, all the classes that we give, besides the legal writing, we have to practice the students in legal writing and answer and analyzing the case and putting an answer and giving an answer about this and trying to resolve that. And we also, of course, really use all these books about legal writing as well. And we are not used to, in everyday classes, use foreign books about legal writing, only Brazilian books.
Excellent, thank you so much. Now, I have a question here by Leonardo Sakahira. It's a question that is more philosophical to both of you, which is the following. How can semiotics influence legal English? So I wonder if Professor Coran would like to say something about that, and then Professor Abate.
I just have to be honest that I haven't given that a tremendous amount of thought in the work that I do. So I will, I'll pass it off to Professor Abate.
I think that with the time that we have in a short time, the scientific study of legal semiotics with specific application to the teaching of law poses a systematic study that considers the distinct fields of research that should not lead to a division only of the interpretive act of law communication. So I think the proposal is when you put semiotics on the legal writing skills teaching, is in the sense of necessary implication of these areas of knowledge, aiming at a total interpretation of the legal discourse in its social environment. And I think it's, yeah, you as semiotics is deals with language, and the law as well deal with language. They are both, yes, of course, we can apply the semiotics in legal writing skills teaching.
Okay, thank you so much. Now we have a question for which is the following. Sometimes that's for both of you. Sometimes when writing in university, we used to have a minimum of words used in our papers. And sometimes for the sake of doing the job, students tend to stretch unnecessarily as we don't know what else to write. What do you, Professor, recommend in order to avoid this? Then I wonder if this time we can begin with Professor Abate and then with Professor Coran.
Well, and I told this is one of the most common mistakes, and I as a teacher, I don't like, it's more honest just to, if you don't know and if you don't know anything about the thing, just don't answer. It's better than to answer anything that's nothing to do with the question. There's nothing to do about the case. And as a professor, believe me, we know that you don't know anything. I think Professor Erica will agree with me. I don't know if, even if we have different students, one from the US and the other from Brazil, I guess they have this in common. What do you think, Professor?
Yes, definitely. And I find students often, we don't have minimum word counts typically in the courses I teach. We have maximums. And I find actually a lot of times the problem really is not going over the page limit because sometimes people tend to ramble or throw things and let me just throw in everything I possibly know about this because just in case. And again, you're dealing with mandatory page limitations on legal filings. Courts don't have a lot of time. I was taught to write as though any judge was only going to look at the first page or only glance at my outline. I had to make even every heading tell persuasively the points I was trying to make because everyone's so pressed for time. So while my students go in thinking, oh, I'm not going to be able to come up with 12 pages for this memo, how am I going to do that? In the end, they're asking, can I just have an extra page? Because they want to throw everything in. So, so that's a really interesting question.
Thank you so much. Now I have another question by Anna Mariucci. which is the following. A bit of is that Professor Karan mentioned effective communication. I was wondering if there is also such a thing as a legal speech course in Dayton.
So I actually also teach an interviewing, counseling, and negotiation course where we really are working on the structure of those oral skills, not the oral argument skills, not the courtroom skills, but those negotiation skills, those getting information, interviewing clients and obtaining their story and counseling them. Some law schools have public speaking for lawyers as well, because that is really so important. We do incorporate oral advocacy in our appellate courses and in our first year curriculum. Every student has to do at least one oral argument. And so far, everyone has survived. We have a lot of students that think they will pass out during that portion of the course. But we also work on those individual client interviewing and counseling skills, because you can't draft any type of legal memo or written document if you don't have your client's facts straight, and you can't get those if you can't communicate effectively with your clients.
Excellent. I think those were all the, oh, just one second. I received another question. What guidance would you give to law students whose first language is not English, if they are struggling to understand and apply unfamiliar terms in their writing? I guess this question is again for Professor Karan.
So my greatest recommendation is to think about language in the way that we learn. We learn first by listening, then speaking, then reading, and then writing. So increasing your vocabulary by reading good legal writing will be helpful. Just familiarizing yourself with the terminology, but reading more, even if you don't understand it, there's a level of absorption. So I like to think of language acquisition in the way that we learn as children. Our first languages, our native tongues. If we approach language that way, that can be really helpful. I also am a huge fan of this, the book, The Plain English for Lawyers. I think it works really well for law students, even second language English speaking law students. I always recommend that book.
Excellent. Thank you so much. I think those were the questions that we had today. Then I wonder if you finally would like to ask a question to each other, if you have questions that you want to ask to each other.
Actually, I think Professor Curran said it's almost, she said everything that I want to know about the US system and the curriculum about it. And I was delighted about her lecture. It was very, very insightful. So I'd just like to thank you for your presentation.
Thank you. Likewise, I learned so much, and I always love hearing about the two-year mandatory practice. I would love to see us have something like that in the United States. I think it's so important, and so wonderful that you have that. So that was wonderful to learn about. Thank you.
Excellent. Thank you so much to both of you. That was a wonderful exchange, and I learned a great deal of what both of you said tonight. Now, I would like to introduce Mrs. Margaret Unides. She is the director of the online LLM of the University of Dayton, and she would like to present the program for us. So, Margaret, you have the floor. Thank you so much.
Thank you, Professor Bernal, and thank you, Professor Neves Abade and Professor Coren, for your excellent presentations. My takeaway from tonight's presentation is that certain aspects of legal writing are truly universal, both in terms of common mistakes and principles of good legal writing. So thank you both for sharing your insights with us. Thanks also to everyone for participating and spending your Friday night with us. As Dean Strauss mentioned, we are honored to be partnered with Mackenzie University and are proud to say that we have 11 Mackenzie students in our online program right now. This Law in the Americas webinar and the full webinar series is part of the internationalization efforts for our online LLM program. As background, an LLM degree is a postgraduate degree in law, and it's typically specialized in a particular field. University of Dayton School of Law, which is accredited by the American Bar Association, historically offered and continues to offer an on-campus LLM program in American and transnational law. Starting in 2019, we also began to offer a fully online LLM option that establishes a path to US bar eligibility for qualified applicants. Through the fully online LLM program, no travel to the US is required since the entire degree and all exams can be completed online. We also offer generous partial tuition scholarships, making our online LLM program one of the most affordable in the United States. Students pursuing the degree online receive the same degree as those students pursuing the degree on campus. The full program can be completed within 1 year or less. There are 12 courses in the curriculum, and you'll be pleased to know that one of those courses is specifically in legal analysis, research, writing, and communication. That course, similar to the course that Professor Coran referenced, incorporates both written and verbal communication. So students also have to participate in an oral argument, even through an online platform. Students take this legal writing course following a course on Introduction to US Law. Also, similar to what Professor Coran referenced for the doctrinal courses in the JD program, we also incorporate short writing assignments in each of the online LLM doctrinal courses. In follow-up to one of the questions that was received, for those, most of the students in our program are not native English speakers. And so we really like to focus on legal writing skills development. We even have an academic success professor that can work with our students and help in terms of writing, not only in legal English concepts, but also the structure used in legal writing in the US, which follows an IRAC format. Our program is offered in 3 semesters per year. Classes begin in January, in May, and in August. Our next semester actually begins on January 11th, and we are currently accepting applications if anybody is interested. We have about 85 students from all over the world currently participating in our program. Some of you are here tonight, so thank you again for joining. And most of our students are working full-time and pursuing other degrees concurrently while pursuing our LLM degree online. Our online LLM program has the broadest appeal for those students who are interested in getting a better understanding of common law and US law in particular, as well as those students interested in expanding their network of lawyers and professors from all over the world. It's especially beneficial for any of you who are interested in careers in transnational practice areas, including, for example, investment, tax, IP, and law and technology. For qualified applicants, our program also provides a pathway to bar eligibility in certain states, including California and Washington, as well as Washington, DC, and potentially we're exploring additional state options as well. If anyone is interested in learning more, we encourage you to visit our website at go.udayton.edu/online LLM. You can also reach out to me directly, Margaret Ioannidis, and to my colleague, Walter Haas. We also would be happy to connect you with Monica Hayes. She's our first online LLM graduate and first bar passer, and she also happens to be Brazilian from Sao Paulo. So although Walter and I both speak Spanish, we don't speak Portuguese, but we do have a member of our team who does. So once again, thank you for joining us tonight, and back to you, Professor Bernal.
Thank you so much. I just wanted to say a couple of final words, is that I was very happy to be here and share this seminar on legal writing. And I would like to extend an invitation to all of you to connect to the next event of our series on law in the Americans of the University of Dayton School of Law. There is a website. I think I cannot share here the link, but if you Google University of Dayton School of Law, Latin American seminars or Law in the Americas seminar, you will see the activities. We have a couple of seminars that are very interesting. One of them is about the regulation of Uber, another platform for transportation across the continent. And the other one is about the right to protest. So I would love to have you in the future in those seminars. Thank you so much. And I wish everyone a wonderful evening.